Good morning. This is an open hearing of the independent inquiry into matters relating to Afghanistan. Please could I ask you to ensure that all mobile telephones and other personal electronic devices are either switched off or in silent mode. Please may I also draw your attention to the fact that the Chair of the inquiry, the Right Honourable Sir Charles Haddon-Cave, has made a restriction order in relation to the conduct of those who are attending this and future hearings. The full order is displayed on the inquiry website and on the door of this court and of the media annex, but I will summarise its purpose. The order, which applies to this and to all future hearings of the inquiry, prohibits any person from making an audio or video recording of inquiry proceedings from within the hearing rooms without the express permission of the chair. Furthermore, no person may take a photograph in any room in which inquiry proceedings are taking place and at a time the inquiry is sitting without the express permission of the chair. For the avoidance of doubt, both of these prohibitions extend to the hearing in the media annex. A further part of the order arises as the live stream of the inquiry proceedings via YouTube will purposely be subject to a 10-minute delay. It is prohibited that any person may disclose, publish or broadcast in any form or by any means anything that is said or done in the inquiry hearing room until 10 minutes after it has taken place. If an application is made for a restriction order in relation to anything that has been said or done in the inquiry hearing room in the preceding 10 minutes, anything that was said or done during that period is subject to a restriction order prohibiting its disclosure, repetition or duplication until the chair has finally determined the application. All of the above orders are subject to a penal notice. This means that any breach of any element of the restriction orders may be certified to the High Court or the Court of Session, who will have the power to fine or imprison anyone found to have been in breach of the order. Court rise. This is an open hearing in Court 73 at the Royal Courts of Justice as part of the independent inquiry relating to Afghanistan. The hearing is before Lord Justice Haddon-Cave, the Chair of the inquiry.
Mr. Glasgow.
Good morning, sir.
I think the temperature in this room has now settled down, so we'll keep an eye on that.
I hope so, and I'll try my best not to raise it during the course of the day. Can I please call Colonel Kristian Rotchell to the stand?
Thank you.
So insofar as his evidence is concerned, can I just give this assistance before we embark on him? So for those who are following.
Yes.
We're going to turn to deal with the background evidence in respect of the Royal Military Police. Colonel Rotchell is going to help us with the structure, the history of the organisation, the deployments that it had in Afghanistan, and will then give us an overview of Operation Northmore and Operation Cestro.
Good. Thank you. Can Colonel Rotchell be sworn, please? Thank you.
I swear by Almighty God that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth. Thank you.
Could you give the court your full name, please, sir?
Sir, my full name's Colonel Kristian Paul Rotchell.
Colonel Rotchell, can I check that what you have with you in the witness box is your witness statement dated the 14th of September of this year?
That's correct.
And it's a statement that runs to 135 pages and contains 272 paragraphs.
Yes, that's correct.
Within that statement, you've referred to a large number of exhibits, and if we need to turn to any of them, we can do so using the screens that are available, one beside you and for others to view in court. If you want to have access to any of the hard documents of your exhibits or to any other material, will you ask me, please, and I'll make sure that's made available for you.
Yes, thank you.
Insofar as your witness statement is concerned, can you confirm that it is true to the best of your knowledge and belief?
It is.
And so, in keeping with the other procedures that we've dealt with this week, could I invite Colonel Rotchell's statement to be introduced into the record, and could it please be uploaded to the inquiry website at the conclusion of his evidence?
Indeed, thank you.
Colonel Rotchell, can I help you at the outset with the progress that I'd like to try to make today? You have set out an executive summary at the start of your witness statement, and at the very beginning, once we've dealt with the formalities, I'd like to take you through that.
Yes.
And then I'd like to descend into the detail. We will take a mid-morning break, I suspect in about an hour and a quarter, there or thereabouts. And that'll give us an opportunity to get about 2.5 or so hours worth of evidence in before lunch. And we'll break, as we've done with everyone else, at 1 o'clock. I don't know that I'll conclude your evidence today. I'll endeavour to do so if possible. But I know that you have very kindly set aside tomorrow to be available to continue your evidence if necessary.
Thank you.
If at any stage I ask something which doesn't make sense, and it's bound to happen, will you please ask me to correct the question, to rephrase it, or just to try something different?
I absolutely will. Thank you.
And also, if you need a break at any stage, will you please ask for it? I can see the clock, and I may try to pay attention to it, but at times I'm not always good with my timing. So if you need a break, just let us know.
Thank you.
Don't worry, I'll keep an eye on that.
Thank you, sir.
Rotchell.
Thank you, sir. Now then, Colonel, insofar as your experience in the armed forces and your position now today giving evidence on behalf of the Royal Military Police, could you set out the role that you currently have and a short history of your service in the armed forces so that we understand how you are in a position to assist the inquiry today?
Certainly, sir. I joined the Army initially in June 1999 and then commissioned into the Royal Military Police in 2003. And in that time, I've been employed in a variety of roles in His Majesty's forces, including multiple RMP roles as a commander, including the command of 3 Regiment Royal Military Police, and also as a staff officer within both the Royal Military Police and in wider Ministry of Defence roles. I've also had the opportunity to serve on attachments to NATO as an instructor with the US Army Military Police and as an exchange officer with the Australian Corps of Military Police. And I've served operationally in Iraq, Afghanistan and Sudan. And I think it's probably worth me highlighting that when I refer to having served in Afghanistan, which I've done twice, both of those times were outside of the relevant period. In terms of my current role, I'm currently employed as the Assistant Head Technical within the headquarters of Provost Marshal Army. That's a position that I've held since February 2002. And in that position, I'm responsible for the development of policing and investigation policy for the Royal Military Police, the governance and resourcing of our investigations. I also provide the focal point for any public inquiries or other judicial proceedings. I'm the lead for oversight and assurance of our firm base, and by that we mean predominantly within the United Kingdom, custodial facilities, and also our lead for external assurance through His Majesty's Inspectorate of Prisons and also through His Majesty's Inspectorate of Constabulary's Fire and Rescue Services. And alongside that, I have a number of other roles. I'm the Senior Responsible Officer for the Royal Military Police for covert policing, for service police information, and also for the delivery of Connect, which is a police information management system that we bring online next week. I'm also the senior accountable individual for service police forensics, and I currently have a role as a Gold Commander where I support the Defence Serious Crime Command.
And just in terms of your training and professional knowledge, because we may need to touch upon some of that in the course of your evidence, you've attended the College of Policing, is that correct?
I have, sir, on a number of occasions, and specifically relating to my current role. I've attended the College of Policing PIP4, which is the Professionalising Investigations in Policing course, which covers strategic management of complex investigations. I'm also a National Police Chiefs Council qualified authorising officer, a course I completed in November 2021. And I've also completed the College of Policing sponsored multi-agency Gold Incident Commanders course, which I did in November 2022.
Just insofar as the first course you told us about, which means that you're now a PIP level 4 investigator, could you just give us the date when you completed that course, please?
Certainly, that was December 22.
Thank you very much indeed. Can I please take you on to the executive summary? And as I said at the outset, what I'm going to ask you to do is to take us through the summary of your witness statement and therefore the structure of the evidence that you're going to give. I'd like to help you explain to us what we're going to be covering so everyone knows the highlights and where we're likely to go. And then when we come to the detail, that's when I'll ask some more questions and we may need to turn to look at a few documents. But so that everyone who is following, particularly those who don't have access to your statement, insofar as what you've set out, did you receive requests from the inquiry legal team to provide certain information to us so that we could better understand the role of the RMP, both generally and in Afghanistan?
I did.
And did you also receive requests from the inquiry legal team to help us with the progress that the RMP had made into investigations of extrajudicial killing that were being conducted in respect of Afghanistan?
That's correct, I did.
And in particular, did we ask for your assistance, or at least the assistance of the RMP, which you have now given, into Operation Northmore and into Operation Cestro?
I did, that's correct.
And have you been able to assist us with other investigations that may become relevant in due course as the inquiry proceeds?
Yes.
In which case, just touching upon your summary, which begins first with the RMP in general, can you briefly help us with a summary of the evidence you're going to give in a bit this morning that touches upon that?
Certainly, sir. And I'll highlight that there were at the time and the relevant period 3 service police forces within the Ministry of Defence, the Royal Navy Police, the Royal Military Police and the Royal Air Force Police, each of which had its own specific service-related role, but at its core had the ability to police and investigate within the powers provided under the Armed Forces Act. And specifically relating to the Royal Military Police, or the RMP as I will probably refer to them as throughout today, as the Army's police force, which existed to provide the necessary military police service to the Army, ultimately to ensure military effectiveness.
In terms of the size of the RMP, can you give us an idea in 2010, so the start of our relevant period, the sort of size in terms of number of either regular or reserve personnel?
Certainly, and in 2010, the Royal Military Police, both the regular and reserve components together, consisted of around 1,800 personnel.
And in 2010, at that stage, was the RMP broken down into 6 major units, 4 concerned with general police duties and 2 which comprised the Special Investigation Branch?
That's correct, as well as some smaller capabilities as well.
And insofar as the 6 major units are concerned, the 4 general police duties units, are they often referred to as GPD?
Yes, they are.
And again, likewise, with the Special Investigation Branch, it may be that we'll be referring to them as SIB.
Yes, that's correct.
As we move forward in the chronology for the period with which we're concerned, and we turn to 2013, had there been a reshuffle within the RMP?
There had been a reshuffle, and by 2013, the size of the RMP had shrunk. At that point, the RMP consisted of, in fact, if you just bear with me 2 seconds, I wanted to make sure I give you the correct number of regiments. But by 2013, the RMP had shrunk to 3 general police duties regiments and 1 SIB regiment.
So from 6 major units to 4?
Correct, sir, yeah.
Can you just help us, please, with the relevance of Provost Marshal Army and what his or her role is? Because that's indeed something we've already touched upon, and we're going to hear a little bit more about it from you in due course.
Certainly. So Provost Marshal Army is the chief officer of the Royal Military Police. They're appointed as such by the monarch, and they have a statutory duty to ensure that investigations conducted by the RMP are done in a way that's free from interference.
And from 2010 onwards, were all RMP units under the operational command of PMA, Provost Marshal Army?
That's correct, and I think we'll probably explore that later, but prior to then, not all units were, but from 2010, a decision was made to place all RMP units under the operational command of PM Army.
And if we consider just briefly for a moment the major units, of which there were 6 in 2010 and then 4 in 2013, is it possible to just give us a brief description of the difference between the general police duty units and the special investigation branch units or unit?
Yeah, certainly so. And in its simplest form, the general police duties units performed, in terms of their policing and investigative function, that would be akin to uniformed police officers within a Home Office police force, whereas the SIB, Special Investigations Branch, performed a role more akin to a civilian police CID.
And since you've touched upon civilian police force, if we're going to draw a distinction between the service police force and the civilian police force, it might be sensible to do so at the outset. Are there, as you've identified, 2 key differences between the Royal Military Police's role within the service justice system and that of a Home Office police force within the criminal justice system?
Certainly. One of the key differences for the service police, of which the Royal Military Police is one of the service police forces, is the way in which offences are investigated, and specifically the way in which they are charged. So the Royal Military Police and the service police in general do not charge with offences. We refer matters to either the commanding officer or to the service prosecuting authority.
And in terms of how you may become aware of offences that you need to investigate, obviously it might start with a complainant who approaches and reports something that has happened to him or her. But if we leave the most obvious means of reporting an offence to the RMP to one side, how else does the RMP quite often come by the information that something has happened that requires investigation?
Well, the second key start point for an investigation within the service justice system is often a referral from a commanding officer who, and I'm sure we'll explore later, has a statutory duty to make the service police aware of certain serious matters.
Can we turn briefly in your summary to consider the role of the RMP in Afghanistan? Because, of course, that's something that we'll have to touch upon in more detail. Insofar as the deployments are concerned, we've already heard from the Chief of Defence Staff, Admiral Radakin, who's told us of the 6-month rotations that were being used for deployment in Afghanistan, and those rotations being given individual numbers with Operation Herrick and then a number thereafter to denote which of the 6-month rotations it was. Was the RMP deployed on Operation Herrick in significant numbers from 2006 onwards?
That's correct. And from 2006 onwards, each 6-month rotation required significant numbers of RMP personnel. In the majority of instances, in excess of 100 RMP personnel for each 6-month rotation.
And we've touched upon the difference between the general police duty units and the special investigation branch units. Was that replicated on deployment?
That was. So on each OPERIC deployment, there would have been 2 key military police entities. The first being what was known variously as either the Theatre Provost Group or the Theatre Provost Company, which was in essence a GPD formation to support the Army's outputs operationally. And the second element was an SIB element, which was known as 62 section SIB throughout the relevant period.
So when we hear of 62 section, that the number doesn't denote any particular deployment or time frame. It was known as that throughout all of the OPERIC deployments.
It was, yes.
Now, one of the matters that Admiral Radakin had touched upon was Operation Entirety and the pre-deployment training and then training that existed whilst on deployment. Insofar as the RMP replicated a cycle of training and deploying and decompression, was that on a similar structure to one which the Army were using?
It was, and it mirrored it. And what that meant for the RMP was that there was a continuous cycle of training, then deploying, and then recovering from operations. And for the RMP, that meant that at any one time, up to 4 of our regular provost companies were committed to either training for being deployed in or recovering from Afghanistan. And the same for the personnel within 62 section SIB.
Did that put a strain on the RMP?
Yes, it absolutely did. The training packages and the requirements to prepare people to the correct standards to deploy them onto operations meant there was intense training and a long lead-in time to allow personnel to get to the required standard, which meant, as I said, that 4 in 2010 of 14 provost companies were always committed to deploying to Afghanistan.
Could we briefly touch upon the role, once deployed, that was performed first by the General Police Duty units that were part of the Theatre Provost Company, and then the role played by 62 Section SIB?
Of course. The Theatre Provost Company provided a number of functions, which we often refer to as either close support functions or general support functions. But once they were deployed, the majority, and in many cases around 70% of the Theatre Provost Company's personnel provided provost close support to combat battle groups, which would include detainee handling and advice, forensic surety in the event of incidents, as well as at many times mentoring Afghan forces, which meant living and fighting on many occasions alongside those that they were employed to support. In terms of,
in terms of the split between their duties, if there was one, is it one that's been described by you and others as being to police the force and police support to the force?
Yes, they're 2 phrases that we use, certainly within the military police, to define what we do in terms of policing the force and providing police support to the force.
And we'll touch upon it in more detail a little later. But when you spoke about RMP personnel living and fighting alongside those they were employed to support, might that also mean that they were living and fighting alongside people who they might end up investigating?
That's an absolute reality of the nature of the operations within Afghanistan, yes.
And then when we come to consider it, I will want to explore with you whether the closeness of the unit had any effect on possible impartiality and whether there might have been any conflict. Okay?
So,
but since we're dealing with it at the moment by way of the summary, I'm not going to go into that now, but it is something I will touch upon. Could I have the same help, please, in respect of 62 Section SIB?
Yeah, 62 Section SIB, as I've already mentioned, was the other key component of the service police and particularly the Royal Military Police deployed on Operation Herrick. And it comprised of around a dozen SIB investigators. And I say around a dozen because, as with any operational deployment, the numbers fluctuated. They were also supported by a number of personnel, generally around 4 from the general police duties unit whose role was to provide crime scene investigation support. But ultimately, 62 Section SIB was there to conduct the most serious and complex investigations in Afghanistan. And
very briefly, if we just think about the numbers that you've mentioned for a moment, and again, we'll touch upon this in due course. If we think in terms of around a dozen SIB investigators who have the assistance of 4 general police duty non-commissioned officers, so somewhere in the region of 16 people making up that unit, they are responsible for investigating the most serious allegations, which involve a cohort of deployed UK Armed Forces servicemen and women, sometimes as large as 9,500.
That's correct, sir.
Would it be fair to say that the RMP, at least as far as 62 Section SIB was concerned, had its work cut out for it?
It certainly did, and alongside the role that I've highlighted in terms of investigating allegations, it also had a key role to play in supporting UK coroners, and the Chief of the Defence Staff highlighted the significant casualty figures from the conflict in Afghanistan earlier in the week, and much of 62 Section SIB's time was taken in ensuring that the best possible support to UK coroners could be provided in the aftermath of fatalities of UK service personnel.
Well, we know from the figures that were given by Admiral Radakin of the 402 servicemen and women who lost their lives that it equated to just over 1 a week during the relevant period that he could identify, which was 8 years.
Yeah.
So we can see straight away that the assistance to coroners must have kept 62 Section extremely busy.
Yes, it did.
And on top of that, as and when required to, 62 Section also had to investigate other serious allegations of wrongdoing, alleged criminal activity and the like.
Correct, sir.
You told us that from 2010 onwards that the PMA was the chief officer of the RMP and that all units were under his or her operational command. And is that the same whilst on deployment? So does that mean that those members of the RMP who were part of the Theatre Provo Company and those who were part of 62 Section SIB were under his command?
Well, Provost Marshal Army's always been the chief officer, but from 2010 onwards, there were changes to the command structures that concerned the Royal Military Police, and I think we'll probably go into more detail in a bit, but in essence, it placed all RMP units under the operational command of Provost Marshal Army, and that remained whilst they were deployed on operations or held within the UK or other overseas garrisons from 2010 onwards.
In terms of command assistance that was provided in theatre, was the UK Force Provost Marshal set up, and that was the most senior RMP officer in Afghanistan, who was located at Headquarters Joint Force Support?
That's correct, and that position was established in 2009 to help Provost Marshal Army ensure their statutory responsibilities were executed.
So that post put in place just before the relevant period with which we're concerned.
Yes, sir.
But designed to give direct in-theatre assistance to Provost Marshal Army, who perhaps wasn't in theatre either at all or very often.
Yes.
To give us some idea of the investigative demand that was faced by the RMP whilst on deployment in Afghanistan, could we just have some idea of the sort of numbers we might be dealing with in due course, and, if possible, a breakdown, if anything, to the types of offences, so we've got an idea at the outset of the task that was faced?
Certainly, and I think it's fair to say that the investigative demand on a small force was high. In the relevant period, the RMP conducted over 1,100 investigations in Afghanistan, of which nearly 200 were into homicide offences, including 8 recorded allegations made against British forces, and another number of investigations into sudden deaths following shootings. I think it's absolutely fair to point out, however, especially when I say that nearly 200 homicide offences, that the majority of those homicide investigations related to the deaths of UK service personnel rather than allegations made against UK forces.
So it would be wrong for anyone to conclude when you mention the number 200 in respect to homicide offences that 62 Section SIB were on a regular basis investigating allegations of extrajudicial killing or murder committed by the British Armed Forces.
Absolutely, sir, and our records would suggest that was 8, not 200.
And those investigations clearly have a totally different focus and direction.
Yes, sir.
And they clearly involve different skills.
Yes.
Insofar as a need to investigate the death of civilian casualties, can you just help us very briefly with your understanding of the relevant policies and law in place at the time? And that will enable us then to turn to deal briefly with Operation Northmore and Operation Cestro. Yes,
certainly. And where civilian casualties occurred on operation, and the MOD had policies that, which we heard about yesterday, shooting incident review policies, that meant where it was immediately clear that there'd been either a breach of the law or of the rules of engagement, that a commanding officer or a person being made aware of that was to immediately ensure the service police were made aware. However, where it fell short of that threshold, then a shooting incident review may take place to determine whether or not there was any wrongdoing. But I think it's worthy of note just highlight quickly that shooting incident reviews themselves were not conducted by the military police. They were conducted by the unit involved.
And again, as you've already said, we'll come to consider those. But insofar as the shooting incident reviews are concerned, the appropriate guidance directed that the commanding officer should seek both legal advice and service police advice before embarking on a shooting incident review.
Where it was possible and appropriate, so yes.
And the onus on a commanding officer is twofold. First, where there may have been a serious offence committed, there is a legal obligation on the commanding officer to report that to the RMP so that they can then investigate.
Yes, sir, a statutory obligation.
That's the first part, which is, would it be fair to describe it as a relatively low hurdle to clear? It's where an offence may have been committed.
Yes.
Okay. And if the commanding officer is not satisfied that that relatively low hurdle is cleared, there's still a requirement on the commanding officer to launch a shooting incident review where a civilian casualty may have been occasioned.
That's correct.
And if the commanding officer follows procedure and is able to follow procedure, then he or she should seek both legal advice and the engagement of the service police before embarking on a shooting incident review.
In its broadest sense, I think different versions of the policies suggest exactly who, whether that's the Royal Military Police or the specific role of the Force Provost Marshal, but yes.
And of course, it's a very trite observation to make, but the Royal Military Police are only able to investigate allegations of which they are made aware.
Absolutely, sir.
And unlike the civilian police force, where members of the public have access to an emergency operator who can, if they so choose, report a crime the moment after it has happened, or can report anything they've become aware of that they think the police need to know about, the facility is not available and was not available in Afghanistan.
No.
There wasn't a number that residents and Afghan nationals could phone to report what had happened.
No.
So either through a third party getting in contact with the RMP on behalf of a family who wish to make a complaint about a bereaved family member, the only other route normally through which the RMP become aware of a serious allegation is because the commanding officer has chosen to bring it to the RMP's attention.
That's correct, a referral from a commanding officer.
And again, we've touched upon it before, but just so that I can confirm that your understanding is the same as the one that we've gleaned in the last few days, there's no difference between conventional forces and special forces when it comes to the obligations on a commanding officer either to conduct a shooting incident review or a serious incident review, as it's called, or to refer matters to the RMP.
There's no difference between any unit within the armed forces in terms of the role and the meaning of a commanding officer.
So that legal obligation on a commanding officer to tell the RMP where a reasonable person would think a serious offence may have been committed would apply to the commanding officer of an SF unit as much as any other units deployed in Afghanistan.
It would.
There are two particular operations which we've already touched upon, Operation Northmore and Operation Cestro. And could we please have a short summary from you in respect of them, and then we'll be able to turn to the body of your statement in more detail.
Certainly. Shall I start with Operation Northmore?
Yes, please. I think for the avoidance of doubt, chronologically, Operation Cestro came first.
It did.
But in the body of your statement, because I think the way in which the questions have been asked of you, it was Operation Northmore first. Can we deal with Operation Northmore first, then we'll turn to deal with Operation Cestro?
Certainly. Operation Northmore was an overarching operational name for multiple investigations, which initially were into detainee abuse and latterly led to allegations of unlawful killing arising from UK operations in Afghanistan. It commenced in March 2014, and investigators examined around 675 allegations from 159 different complainants, encompassing a range of offences. The most serious allegations, however, related to unlawful killing by members of UK Special Forces, which were not reported to the service police at the time and came to the attention of Operation Northmore after it had commenced looking at detainee abuse allegations.
And just so we've got an idea of what you mean by after Operation Northmore had come to look at the detainee abuse allegations, we're talking about a time gap of several years in between the allegations are said to have occurred and when they were brought to the attention of Operation Northmore.
That's correct.
Insofar as the scale of the task that lay ahead of those working on Operation Northmore, did resourcing for an operation of that size become a critical and contentious factor?
I think it's fair to say resourcing was a critical issue for Operation Northmore, and particularly in the provision of suitable facilities to exploit the documentation that was required because of its national security classification, and it required lots of engagement between the RMP and an area of defence known as the Defence Infrastructure Organisation to enable that capability to come online, because it didn't exist at the time that Operation Northmore commenced.
And whilst the operation commenced in March of 2014, it was not until nearly 2 years later, 2016, that the ultimate home of Operation Northmore was identified.
That's correct. It was identified slightly before that, but it was 2016 before they were able to move into it and operate from it.
So around about 2 years in between the start of the investigation and the team itself being housed together in the place where the investigation was to be conducted from.
Yeah, that's correct.
And I think it took nearly another 2 years until 2018 before all the necessary resources were in place for the Operation Northmore team to operate at full capacity.
That's correct.
But the operation itself was declared closed in July of the following year, July 2019. And with your help in due course, we'll look at the conclusions that were reached. But it's right to say that in the investigations that Operation Northmore had conducted, the conclusion was that the evidential sufficiency test was not met for any of the unlawful killing allegations.
That's correct.
In other words, in layman's terms, there wasn't enough evidence to prosecute.
Well, there wasn't enough evidence to refer to the Service Prosecuting Authority to consider a charge.
But of course, that wasn't the end of the matter. It still had to be referred to the Service Prosecuting Authority because that's the obligation on the RMP.
There's a statutory obligation placed on the RMP and the service police as a whole, which is covered in section 116 of the Armed Forces Act, and that governs that where a serious offence appears to have occurred and the service police decide not to make a referral to the Service Prosecuting Authority, they must consult with the Service Prosecuting Authority first.
So, in a sense, a safety check or a double check on any conclusion the RMP might have reached about whether or not to prosecute someone.
That's correct.
And when we talk about the Service Prosecuting Authority, that is a body staffed by lawyers from the three services and headed by the Director of the Service Prosecuting Authority, the DSP.
Yes.
And when it came to the conclusions that the RMP had reached in respect of the unlawful killing investigations, those conclusions were referred to the Director and to the SPA so that lawyers could check whether the RMP's conclusions were in fact correct.
That's correct, sir.
And the Director and the SPA agreed?
They did, yes.
Could we just have your help on Operation Cestro, please, which is slightly different because unlike Northmore, which took some years to be brought to the attention of the RMP, Operation Cestro was brought to the attention of 62 Section much earlier on.
It was, and in common with Operation Northmore, Operation Cestro, or the allegations that led to Operation Cestro, were never formally reported to the RMP by the unit involved. But through other means, the RMP were aware of them within a matter of weeks, and the investigation commenced as soon as 62 Section SIB were informed. Unlike Operation Northmore, Operation Cestro, rather than being an overarching investigation, was a specific standalone investigation which was concerned with a single incident of an alleged unlawful killing. And although it didn't commence immediately, it commenced as soon as the service police were aware, and therefore it was able to take that contemporary evidence, and therefore the outcome of Operation Cestro was that it did lead to referrals of 3 personnel to the Service Prosecuting Authority.
And again, we'll touch upon that in a little more detail, but despite the referrals that have been made by the RMP, the conclusion reached by the Director of the Service Prosecuting Authority in conjunction with SPA lawyers was that those individuals were not to be charged.
It was.
Presumably the RMP's experience, having been deployed on a number of 6-month cycles in Afghanistan, has provided the RMP with a number of lessons to be learnt.
It has, and we've learnt many lessons, and we continue to evolve and continue to seek to use the experience of investigations that we've conducted and operations that we've been deployed on to ensure that we're best placed to provide the right service to meet the needs of defence and also to the victims of crime. And we remain on a pathway of continuous professionalisation to ensure that all our people are compliant with the best practice that we can put in place. And where we identify those issues, we will seek to rectify them.
And again, something we'll touch upon later in your evidence, there have been a number of different reviews of the service justice system and of the Royal Military Police, all of which have made a large number of different recommendations. And where possible, has the RMP done its best to take notice of those recommendations and to incorporate them into the way the RMP trains its own investigators and investigates offences?
Where possible, we have done, and I think it's probably worth at this point just highlighting one of those, which is our movement towards utilising the PIP process, which I mentioned earlier, the professionalising investigations in policing pathway, which the RMP and the Defence Serious Crime Command are now firmly on, which will see all of our personnel achieve PIP 1 by March of 2024, and DSCC seeking to have all of its personnel PIP 2 trained as soon as possible.
And was that a decision that was taken in light of the recommendations offered by Mr. Justice Henriquez?
It was, yes.
And presumably the RMP welcomes opportunities such as an inquiry like this to reflect on the way that it carries out its role and on any improvements it might make to the way it does that.
Absolutely.
Can we turn to deal with the substance of your statement? And you began with the organisation and structure of the Royal Military Police. And we'll look together at that if we can. It begins at paragraph 26. And what I'd like to do is to have your help in explaining in a little more detail the significance that there is for a separate service justice system alongside the civilian criminal justice system, and also to explain to us the difference in the powers that service policemen and women have rather than home office policemen and women. And you'll be able, I hope, to give us a little bit of the history of the RMP, but we're not going to embark on that in too much detail.
No, of course. And to firstly address the separate service justice system, it's been a long-standing view of both Parliament and senior military commanders that a separate service justice system is necessary. And the reason it's necessary is to provide a comprehensive system of command and discipline to enable the operational needs of defence to be met. Ultimately, the service justice system is fundamental to allowing defence to operate effectively. A key component of that is the service police, and the service police carry out their functions in line with the relevant legislation. And I think it's worth highlighting the Service Police Codes of Practice, which in essence applied the provisions of the Police and Criminal Evidence Act to the service justice system. The service police are distinct from their civilian counterparts, as we have unique tasks that don't have a direct equivalence. So other agencies can and do investigate, but only the service police is able and has the capability to deliver that function and that full range of policing functions on operations and across a spectrum of different tasks in different locations in support of the defence needs, both at home and abroad.
And when you talk about its ability to function and to exercise its powers both here and abroad, should we understand from that that servicemen and women are subject to the appropriate legislation no matter where they are in the world?
That's absolutely correct. The Armed Forces Act sets out that service personnel are subject to both the law of England and Wales wherever they're employed in the world, and that's mirrored in the powers of the service police.
So the service police then have the ability to carry out investigations you might normally expect to be carried out in the United Kingdom, but anywhere in the world, depending on where service personnel are deployed.
That's correct.
So when we think of the deployment of RMP units to Afghanistan, obviously the geography, the language, the culture, and the kinetic situation brings with it different challenges, and we'll think about those a little later. But in effect, the RMP are doing what they've always done back in the UK. It's simply moved to a different environment.
Yes, the context has changed.
That, of course, is not meant to diminish the role that any of the RMP officers played alongside the soldier first principle, which saw them deployed as soldiers as well as investigators.
That's correct.
You told us at the outset that there were, at the relevant period, 3 service police forces within the Ministry of Defence: Royal Navy Police, Royal Military Police and Royal Air Force Police. And presumably each has its own particular service functions that are unique to the service that it is intended to police.
That's right. I think most importantly, at the core of all those organisations are the powers and the ability that's set out through the relevant legislation to allow them to both police and to investigate all members of the services. But within their own single service, each has its own unique role. For instance, the RMP's role is to support the Army on operations predominantly in the land environment, whereas the Royal Navy Police have roles in the maritime environment, and likewise the Royal Air Force Police have their own service-specific functions.
And just touching on it briefly now, there has been a complete shift in the tri-service police approach since December of last year, when the Defence Serious Crime Command was established, which in effect brought those 3 service police forces together under one roof.
It did, and again that was another recommendation by Sir Richard Enriquez, and as of the 5th of December 2022, the Defence Serious Crime Command exists with the remit to investigate all serious and complex crime within defence.
Yeah, so no matter which of the 3 services it comes from, it's the DSCC that one turns to.
Yes.
Very briefly, if we can, insofar as the Royal Military Police is concerned, have Provost Marshals been appointed since the early 16th century?
I believe so, yes.
And is the purpose of a Provost Marshal to assist in sustaining the environment within which military capability can be generated and fighting power applied?
Yes, in order to allow, in the Army context, the Army to fulfil its mission.
And as you've already said, the RMP has a unique capability to deliver a range of functions, as you've termed it, throughout the spectrum of conflict.
Yes.
So different skills to Home Office police forces.
Yes.
But sharing some of the same skills.
Ideally sharing the best practice and applying that to the environment or the operation in which the RMP finds itself operating in.
Mr. Glasgow, could I just, picking up Mr. Glasgow's point about the history of the PM back to the 16th century, can you use quite an interesting phrase that having a separate service justice system is fundamental to enable defence to operate effectively. Can you expand on that a bit?
In terms of the importance of the service justice system, it's critical that soldiers on operations are held to account where things go wrong. It ultimately provides, or a service justice system provides a license for defence, or supports the license that defence has to operate. Because without a separate service justice system, there would likely be an inability to quickly and effectively deal with any transgressions committed by soldiers, sailors and airmen, wherever they were serving in the world. Historically, there have been issues with legislation which mean that some personnel committing certain types of offences overseas, for instance, were not covered by domestic legislation, but were covered by the Army Acts and the equivalent Single Service Acts. So if defence wants and needs, and it does need to be able to hold itself to account, it must have a justice system, a service justice system that allows that to happen, because without it, the confidence of the United Kingdom, both in terms of government and the population, would rightly be diminished in the ability of the armed forces to operate.
Thank you, Mr. Glasgow.
And just so we're clear about the ambit of the service justice system, because it may be easy at times to fall into the mistake that we're concerned only with criminal transgression. It is one purpose of the service justice system to deal with criminal transgression, but the other to deal with service offences, so those that are unique to military life.
Absolutely, and Brigadier Ebel yesterday described one of the values and standards of the Army being discipline, and discipline is absolutely fundamental to everything that we do. And therefore, to allow us to apply that discipline, there are a number of offences that sit under the Armed Forces Act, the first 37 or 38 offences in the Act, that are not criminal offences, certainly within the jurisdiction of England and Wales, but are pivotal to allow defence to maintain discipline. For instance, a soldier going absent without leave, it may be seen as just not turning up for work, but if a soldier doesn't turn up for work at the right time, then that has a significant impact on the discipline and the effectiveness of forces. And likewise, other bespoke offences such as hazard in a ship. Hazard in a ship is critical to the Navy in the same way a disobedience to a lawful command is significant.
Because as you've said, discipline is one of the fundamental tenets of the armed forces, and people are expected to do what they're told.
Without it, it's very hard for a uniformed service to operate effectively and fulfil the needs of the nation.
Because ultimately, it's obedience not only to law and order, but to command and order.
That's correct.
Could we just have your assistance, please, on this one matter? Because whilst we've touched upon the fact that as of December last year, the Defence and Serious Crime Command has now drawn the 3 SIB units together as one. At the time with which we are concerned, of course, there were still 3 separate police forces and therefore 3 separate special investigation units. Does that mean that only the RMP can investigate the Army and only the Navy can investigate the Navy?
No, it doesn't. And the introduction of the Armed Forces Act 2006 applied the same powers and the same provisions to each of the service police forces. So whilst predominantly we would see or would have seen in that period the Army through the SIB investigating Army personnel, and likewise in the other services, there's no reason that it had to be that way. And certainly there are many instances where that hasn't happened, and in fact a bespoke protocol exists between the 3 service police forces to ensure that if there were ever or are ever instances where the role of one in investigating a matter may be compromised, that one of the other service police forces, SIBs, could investigate it.
Is that the tri-service investigation policy?
It is, yeah.
So that provides specific powers that are shared between were then shared between the 3 police forces.
Yes.
In the event of a conflict, one of the other 2 would take over.
Yes.
Insofar as the RMP in general, in the period with which we are concerned, as you've told us, Provost Marshal Army was the head of the RMP and responsible to the Chief of the General Staff for the delivery of independent, effective investigations, and also providing safe and secure custodial facilities for anyone who might be subject to a period of detention.
That's correct. I think it's worth just exploring what that means in terms of command, because we've heard earlier in the week about command states, and we may go into them shortly. But in terms of full command of the RMP sits with the Chief of the General Staff, because the RMP is an army unit, and the Chief of the General Staff has full command of all army personnel. To ensure that the Chief of the General Staff and the Army are not responsible for how the RMP conducts investigations, a provision was placed into the Armed Forces Act through an amendment in 2011, and that's section 115 alpha, and that talks about the Provost Marshal's responsibility to ensure that investigations are free from interference from anyone who is not a provost officer, and a provost officer being a service police officer. And that duty is owed not to the Chief of the General Staff, rather to the Defence Council itself.
So a statutory recognition and obligation that RMP investigations should be free from any interference.
Yes.
So notwithstanding the fact that the PMA is responsible to the Chief of the General Staff, when it comes to the conduct of investigations, he or she, the PMA, is in sole charge of the direction that any investigation might take.
Yes, and responsible to the Defence Council.
You told us that at the start of the relevant period in 2010, the RMP had around 1,800 personnel. But just so we understand the immediate structure that sat beneath the Provost Marshal Army at that point, was Provost Marshal Army supported by 4 deputy Provost Marshals?
Yes, that's correct.
And how were the 4 roles separated one from the other, please?
So the 4 roles, which at the time were known as Deputy Provost Marshals, and they were officers in OF5 or Colonel rank. The first was the Deputy Provost Marshal who covered operations, sometimes referred to internally as DPM Ops, and they were responsible for the operational output of the RMP. The second was DPM IMV, or Deputy Provost Marshal Investigations. Their responsibility was overseeing investigative policy and output. The third was Deputy Provost Marshal for Custody and Guarding, and their role, as I should highlight, Provost Marshal Army is also responsible for the military provost staff, who are in essence custodians within the Army. They run the Military Corrective Training Centre in Colchester, and also a number of other smaller facilities around the UK and the world. Provost Marshal Army is also functionally responsible for the Military Provost Guard Service, who provide an armed guarding capability to many defence sites, and therefore Deputy Provost Marshal Custody and Guarding oversaw those functions and requirements. And then the fourth Deputy Provost Marshal was Deputy Provost Marshal in charge of historic investigations and inquiries. And in the time period, in the relevant time period, and from 2010, that saw significant volume of work for the RMP relating to historic inquiries and investigations, and it was deemed that that fourth Deputy Provost Marshal was required to assist with that.
And just taking us to the end of the relevant period with which we're concerned, so to 2013, you already touched upon the reduction in the number of units from 6 to 4, and that we now had 3 general police duty units and 1 special investigation branch unit. In terms of the structure of that single SIB unit, was it broken down into 5 separate companies which had different geographical focus?
It was.
And was one of those, For Investigations Company, as it was called, responsible for all overseas locations, including Afghanistan?
It was.
And for the avoidance of any doubt, when you told us about the requirement to commit so many units on a training, deployment and decompression cycle, is it only SIB members from For Investigation Company that saw themselves sent out to Afghanistan, or because of the cycle and the number of people involved, did you have to use SIB investigators from the other investigation companies?
The volume of individuals required to fulfill the commitment, and particularly the reality that to have 62 section fully established in Afghanistan at any one time required between 3 and 4 times the number of personnel, meant that the investigators came from across the from across the different SIB companies within the RMP.
And again, for the avoidance of any doubt, whilst they were separated one from the other by reason of the geographical location or focus that they had, was there any difference within those 5 companies to the skill sets of the SIB members?
No.
You told us about the difference in the skills that would be relevant for either a general police duty or SIB unit member. And in the broadest sense, you'd said that the general police duty or GPD personnel were the equivalent of uniformed police officers as we would know them to be from any of the Home Office police forces, and that the SIB were more similar to the CID. So we think of terms of, in effect, much as we do with the domestic and Home Office police constabularies, on the one hand, uniformed police officers, and on the other, specialist investigators.
Yes.
Insofar as there is a difference in the sort of work that might be carried out either by the general police duty teams who were part of the TPCs or by the SIB who were part of 62 section, as far as investigations are concerned, can you just give us an idea of the sort of differences between a GPD investigation and an SIB investigation?
Yeah, so in the, perhaps the best way to explain this is to articulate that SIB investigations would be into serious and complex matters, or those that posed significant or had significant complexities that meant they wouldn't ordinarily be dealt with by the GPD units. The GPD units, on the other hand, would be more focused on initial management of actions at scenes and initial response to issues, as well as investigating those offences that would be deemed as less complex, for instance, perhaps thefts and lower level assaults, whereas the Special Investigations Branch personnel would be looking at those offences such as sexual offences, serious assaults and perhaps serious financial crimes as well.
In terms of the number of trained and qualified SIB investigators, in 2010, was it around about 150?
Yes, from the information we've been able to glean, it was around 150.
And by 2013, and I'm choosing those dates because they're the relevant period with which we're concerned, but by 2013, had that increased to around about 220?
It had, and that number has come from some evidence provided in another proceeding at the time. I think it's probably worth clarifying that increase between 150 to 220 sounds significant because it's an increase of almost 50%. I think the reality of that is there was a marginal increase in the number of trained investigators, and the majority of that increase is likely to be those personnel who formed the supporting elements of the SIB regiment when the SIB regiment was formed in 2013.
Insofar as the qualifications that there were of those individuals who were deployed as part of 62 section SIB, you've told us that they are dealing with offences of complexity, of gravity, and clearly those that require trained investigators. Can you help us with the sorts of qualifications that your deployed investigators had to equip them with the necessary skills to conduct investigations of that complexity and gravity?
So within the relevant period, the two key courses that were conducted by our investigators were courses run by the Defence School of Policing and Guarding. The first one was known initially as the Level 2 Investigations course, or latterly as the Volume Crime Investigations course. And that course qualified individuals to be investigators. And then for our specialist investigators, they conducted a subsequent course, which was initially known as the Level 3 Investigations course, and subsequently has been referred to as the Serious and Complex Crime Investigation course. That was within the relevant period the key qualifying criteria for an individual to investigate serious and complex crimes within the Royal Military Police.
If we just think about the rotations for deployment, so every 6 months, which sees a new set of SIB investigators being deployed, and we also have to be cognizant of the fact that there was at that stage a rolling shift on every 2 or 3 years where people would move around within different roles. Just focusing on the change every 6 months, is there a danger when you're pulling investigators out and putting new investigators in that either skills or knowledge of particular investigations might be lost because those who had been in theatre take knowledge and skills with them, and those that go out arrive cold and fresh and have no knowledge of what's been going on hitherto?
There absolutely is a danger of that, and at the time that there were attempts to mitigate that by ensuring that as part of the pre-deployment training for each element of the SIB and of the Theatre Provost Company going out, received briefs from those people in theatre at the time, so those who were currently doing the role in Afghanistan, to inform them of best practice, to inform them of changes, of themes, to allow them to be best placed. I think it's important to highlight as well, though, whilst there is a danger of removing people from the operational theatre where they have the knowledge, there's also an intrinsic danger of leaving them in that environment for too long. And I'm sure later on we'll go on to cover some of the challenges of operating and investigating in Afghanistan. But leaving people for too long would have posed different but equally challenging issues for us. So the mitigation came from cross-briefing and comprehensive training.
And the second part of what was an unhelpfully long question, so I'm sorry about that, but the second part was that is there an impact on the decision for people to rotate every 2 or 3 years through different jobs that sees them either lose skills or unavailable to pick up skills they might need for the next post?
So if I can perhaps answer this in 2 parts, because I think it's a very valid area that has been raised previously and in external studies of the RMP. In terms of our general police duties personnel, they have a real breadth of roles that they go into, and therefore there perhaps is some skill fade if going from one role to another. In terms of our, and to address it then from the perspective of the SIB, we've already highlighted that the 5 at the time, 2013, SIB companies broadly fulfilled the same role with a slightly different geographic focus. So the rotation from one of those roles to another one was unlikely to see a significant skill fade because the specialist investigators were ultimately fulfilling the same role. And the majority of our specialist investigators, once they enter the SIB, tend to spend the majority of the rest of their careers within the SIB career field.
And just one last matter before perhaps it's a convenient moment for our mid-morning break, and it's this, because since we're touching upon skills, skill fade or appropriate skills, and recognising that the rotations are only 6 months in duration, what you told us about the number, particularly of homicide investigations, is that in the main, it was SIB officers assisting UK coroners to better understand how it was that a serviceman or woman had come to lose their life whilst on deployment. And that a very small number of those homicide investigations actually concerned extrajudicial killings or allegations of murder made against service personnel. So if we think about that for a moment, we have a relatively short window of 6 months and someone who is going to be exposed perhaps to very few, if any, murder investigations where the suspect is a British serviceman or woman. Is there any difficulty, do you think, in your investigators being able to get up to speed to deal with an investigation which is rare in terms of what comes across their desk, might be the only one of its kind in a particular deployment, and might even be the first time they've ever looked at something like that?
I think, and I think we'll touch on it later, but I think Cestro might be a good example of this, and because when the unit that was being investigated returned to the UK and the investigators investigating it returned to the UK at the end of their respective deployments, the overall control and conduct of the investigation was not held in Afghanistan with 62 section. It moved back to the UK to enable that continuity, which was, I think, both sensible and also very practical, given that many of the lines of inquiry, not all, but many, existed within the UK. So, and that's something that we saw on a number of occasions.
Is it a fair observation to make that for some of the SIB investigations, when presented with an allegation of EJK or murder by a British serviceman or woman, it might be the first time they'd ever had to investigate that sort of allegation?
That's fair.
Do you think that gave that particular SIB investigator a steep learning curve ahead of him or her?
I think it's difficult to answer that with any real clarity, because I suspect everyone approaches that first experience differently. But there were other people around, both within the broader SIB regiment and more broadly across the service police, who could assist with that. And at times the RMP also sought to mitigate that by using external advice, which I think we'll dip into later on.
So would that be a convenient moment for a break this morning?
It would, Mr. Glasgow. Thank you. We'll break now till 11:30, please. Thank you. Thank you, Mr. Glasgow.
Please, sir. Colonel Rotchell, you've been able to help us with the powers that the SIB exercise and the way that they work both nationally and then internationally. Can we just have your assistance, please, in the expectation that the Army has that servicemen and women will cooperate with the RMP as and when an investigation begins? Because I've already touched upon very briefly the fact that we have the SIB and the GPD working hand in glove with those they might need to investigate. And clearly, thought must have been applied to how to deal with that difficulty and what expectation there might be on British servicemen and women to assist any investigation launched by the RMP.
I think the easiest way for me to describe that is perhaps to refer to Queen's regulations as they were at the time, King's regulations now, which I believe a previous witness has signposted to the inquiry. They're the regulations that underpin everything that is done within His Majesty's Armed Forces. And there is an entry in Queen's regulations as they were and was at the time. And if I read it out, it says, the chain of command has a clear duty to assist the service police and to facilitate their inquiries. Obstructing or failing to assist a service policeman may be an offence, as may interference with an investigation. Compelling reasons are required before assistance may be refused, and assistance should not be refused without seeking legal advice. So, to take from that, it's absolutely incumbent upon all service personnel and the chain of command to support service police officers and their investigations at every opportunity.
Simply to complete the quotation which you have just read to us, is there also a caveat at the end of it, which is that none of these provisions imply any legal obligation on an individual to provide a statement?
There is, that's correct.
So whilst there is an expectation that all service personnel will assist a service policeman, and that indeed obstructing or failing to assist may be an offence itself, there is no obligation on any member of the armed forces to provide the RMP with a statement into any matter into which the RMP is inquiring.
That's correct.
And it may be something that we'll have to come back to a little later, but in terms of being able to conduct an effective and thorough investigation, if all that's required is assistance and cooperation, but no obligation to put your name to a statement, does that mean that it's almost a threat without any real consequence?
I'm not sure it's a threat without consequence, but on the face of it, it could be challenging at times.
And if we just think about the environment in which the RMP were deployed on their 6-month rotations, at that stage there was an expectation that it would be soldier first. So that they were principally soldiers, but also at the same time they were investigators or officers of the RMP. That they are living and fighting alongside the people that they might be called upon to investigate.
Yes, and that's absolutely a reality that they were.
And they have, of course, the Queen's regulations, as they were at the time, which they can wield, which imposes an obligation on anyone to assist and cooperate with the investigation. But they don't have a power to say, and what's more, thank you very much for what you've told me, but now you have to give a statement.
No, but I think that has to be taken in the context of all investigations in which there's not always a power to compel anyone to give a statement to the police during an investigation.
In a structure where obedience is so significant, is it a frustration for the RMP that they don't have a power to compel people to provide witness statements in situations where a person might have important evidence to give?
I think it would be very helpful if they could.
Can we just touch briefly on the soldier first principle? I've asked you about it on a number of occasions, but just so we understand what the expectation was of RMP personnel who were deployed on the various rotations of Operation Herrick. You'll find it in your statement of paragraph 68 onwards. And at its core, did it begin with an expectation that all RMP personnel would have the same soldiering skills that anyone else on deployment would have?
It did, and that's a critical requirement to enable those members of the RMP as soldiers to be able to deploy on operations around the world. As we've already covered, wherever the Army operates, there's a need for the RMP to operate, to ensure and maintain discipline, to ensure the Army's operational effectiveness. And therefore, soldier first was a phrase that was coined that tried to codify that. I think it has at times been misunderstood, but the reality is the soldier first principle is an enabling activity to enable RMP soldiers and officers to be at the requisite standard to be able to deploy to the theatre in which they're required to operate.
In terms of the fact that it may have been misunderstood, can you just expand on that, please, so we understand how it is you draw that conclusion? And it may be that it comes from the review of Mr. Justice Henriquez, who made certain observations and recommendations in respect of the principle of soldier first. But could I just ask what your understanding is of the misunderstanding that there might have been?
Mine comes from the Henriquez report as well. In fact, sorry, so if I can just correct myself, mine comes from the 2015 HMIC FRS report, not the Henriquez report.
That's my fault, and I've misled you, and I'm very sorry for doing so. Just if we turn to the screens for a moment, if we were to look to exhibit page number 85, please, thank you very much indeed, and to the last bullet point, in respect of the conclusions that were reached by, as they then were, Her Majesty's Inspectorate of Constabulars, Fires and Rescue Services. The good news is that your screen's come to light and mine hasn't, so I'm just going to read from a different document. I suspect I tried to press the on button and have actually turned it off. Miss Broom, as ever, has come to my rescue. If we looked to the last bullet point in the summaries and conclusions that are set out on this page, central to the strategy of the Provost Marshal is the commitment that the RMP will be soldiers first and police officers second. This means that as well as their police training, RMP staff need to be trained and ready as soldiers for combat conditions to enable them to carry out policing duties in demanding and austere conditions. However, when we spoke with RMP staff, we found that this message had been interpreted by some junior and senior officers that soldiering duties and training should be so much more of a priority than policing duties and training that the policing element had been neglected. Now, clearly, that's one of the recommendations and conclusions that the RMP will have been cognizant of and will have taken steps to remedy. Insofar as there is still a risk that soldier first means the RMP are more concerned about their soldiering skills than their policing skills, is that a concern that we should be cognizant of today?
I think it's very relevant because it's been identified by HMIC FRS. I think since that report in 2015, steps have been taken within the RMP to codify and ensure that police training and we've referred, you heard yesterday about MATs, or the military annual training tests. The RMP has instigated a process of what were known colloquially as policing mats, to ensure that those policing skills and investigative skills received equal credence and were also annually checked. And then I think more importantly, and I've already briefly touched on it, but ensuring that all our personnel maintain national level and nationally recognised standards, and perhaps more importantly, maintain those standards, because I think this is about maintenance of skills rather than being taught something once and then moving on from it, but maintain those standards so that they're able to demonstrate effectively now and in the future that they are competent and capable to deploy on operations and conduct effective and efficient investigations.
Just if we think about it at its most basic level, and I don't mean to labour the point, but so that everyone has an opportunity to hear how the RMP consider it should be approached. If as an RMP serviceman, I am deployed on a 6-month rotation and I live, work, fight alongside people who ultimately I need to investigate because they're accused of an offence, is there a danger that I might struggle to be objective because I'm being asked to investigate my friends or my colleagues at its lowest level?
I think there's always a danger of that, and I think what's therefore important is that we do everything that we can to minimise the impact of those very human emotions that you refer to. And it's perhaps worth me highlighting a few of the systems in place to try and prevent that. And first and foremost, every warrant card holding member of the service police is an investigator to a certain level, and it's therefore incumbent upon them to ensure that they act with the courage and the discipline that we heard about yesterday. And certainly within the service police, we have our own internal practices and procedures, which I suspect we may explore later on, that set out the importance of doing the right thing in a difficult circumstance, which is the baseline that we expect from our people as service police officers and as members of the armed forces. But beyond that, wherever it was possible to do so, those individuals that were living and fighting alongside individuals just conducted the basic investigative actions that were required to ideally buy time and space to allow the specialist investigators to come in and take control of those investigations. But it's absolutely essential that the closest person to an incident, and to refer back to those instances where matters are going before UK coroners, particularly securing enough evidence at the scene, be that physical or witness accounts, to be able to provide an honest and accurate account back. And that same principle applies in criminal investigations that were conducted on operations as well.
Does the RMP set and expect very high standards of both its officers and its NCOs?
We do.
And in terms of maintaining those standards, do you have an eye to those members of the RMP who fail to meet the grade, and either to retrain them or to reassign them where appropriate?
We do, and I can, without giving specifics of examples, I'm aware of a number of occasions where individuals that have failed to meet the predominantly the values and standards of the Army, but the specific standards that the RMP has set through various documents, including our own code of conduct, MP compass and moral compass, who have been either discharged from the service or who have been removed from the Royal Military Police and had to seek employment elsewhere in defence. And in terms of safeguarding that process going forward, we are now embarking on a significant campaign of vetting every single one of our personnel against national standards, utilising the NPPV, non-police personnel vetting process, to ensure that, one, we get the right people in to our organisation, and then once they're in, that they abide by the values and standards that the Army sets and the code of conduct that we expect as a service police force.
In terms of what you expect of your service police men and women, is that exemplified by the RMP motto?
It is, yes.
By example, we shall lead.
Yes.
So you expect your servicemen and women to set the example for the rest of the British Armed Forces?
I think it's imperative that we do.
Insofar as how you are able to equip them with the skills that they will need to lead by example, could we just have your assistance, please, in respect of the training that was provided to any of the deployed individuals who went out on the op-HERIC rotations? I think you'll find that is set out in your statement at paragraph 73 onwards. I know that you've given other information about other recruitment policies and, for example, how someone might join as an officer, but what I'd like to focus on at the moment is the training that was provided and role-specific training in 2010 that would, at least according to the RMP, properly equip service personnel for their deployment.
Yes, certainly. In 2010, there were two key basic police courses, which I will explain in a little bit more depth. The first pertains to those individuals who joined the Army as soldiers and subsequently moved into the Royal Military Police. And our junior non-commissioned officers would have completed a course at the time which was 15 weeks in duration. That was known as the RMP initial course. To provide a short breakdown of that, it includes 7 weeks of investigative training and followed by 4 weeks of what we termed at the time environmental training. That was really the practical application of the previous 7 weeks training. So their knowledge and their skills would have been practically tested, but in a simulated and scenario-based manner. The remaining time on that 15-week course, the 4 weeks at the end, were devoted to operational military police training. Officers enter in the Royal Military Police at the relevant period, and in 2010 completed a course known as the Royal Military Police Officers Course, which was 12 weeks in duration and included 6 weeks of investigative training and only 1 week of environmental training, with the remainder of the course being dedicated to operational training.
And insofar as it was possible, was an effort made for the training that you provided to your junior NCOs and your officers intended to mirror that of Home Office counterparts within the Home Office civilian police forces?
Yes, whilst accepting the slight nuances of the service justice system.
Were there additional courses which were introduced later and which the junior NCOs were expected to complete, as well as investigations courses and the like? So could you take us through those, please, so we understand the full complement that was available?
There were, and from late 2010 onwards, all junior NCOs that went through the initial course were also required to complete an advanced apprenticeship in policing, which comprised of a functional skills area. It also included a City and Guilds Level 3 diploma in defence policing and another City and Guilds diploma in policing. And the final aspect of that was a competence-based training followed by an assessment which required each of our junior NCOs to meet what were at the time the national occupational standards in policing. That didn't occur whilst they were on the RMP initial course. That occurred as functional training when they moved to their first unit and was routinely conducted within their first 2 years of service in what we would refer to as the field army.
And in terms of further courses available during career progression, were personnel sent on numerous policing and investigation courses with the College of Policing, and also to work alongside the Home Office police forces in order to better their skills?
So they were. I've already highlighted the volume crime investigations course and the serious crime investigations course as key internal foundations. I think to try and equate them now, they would certainly, the serious crime investigation course would broadly, very broadly, equate to a PIP2 equivalent course. What that left was a gap beyond that, particularly in terms of our SIO development, which we didn't have the ability to train in-house through the Defence School of Policing and Guarding. So we utilised College of Policing programmes to do that, and particularly we used the SIO, or Senior Investigating Officer Development Programme, externally through the College of Policing.
Was that programme available for RMP SIOs at the relevant time, or is that something that's come in more recently?
So that was available at the relevant time. What that's now been replaced with is the PIP3 pathway, which again is provided to us through the College of Policing.
You told us that you are PIP4 qualified.
I've attended the PIP4 course. I think it's really important to be clear that I am not an accredited PIP4, which is part of the lessons process that we are learning on that PIP pathway, because it takes several years, perhaps half a generation, to move people all the way through that pathway. So to try in the best way that we can, both the RMP and the Defence Serious Crime Command are taking the best practice and the knowledge from those courses, but we accept that it's going to take us time to get to the level where we have fully accredited both PIP3 individuals. We should see that within the next 12 months, and therefore a number of years beyond that till we see fully accredited PIP4 individuals.
So when we're talking about the PIP qualifications, so the Professional Investigations Programme, that's something that's relevant outside of the relevant period with which we're concerned, because it's a present day matter.
It is, yes.
It's not something that was in place before, and certainly not at the time that anyone was deployed between mid-2010 to mid-2013.
No, not the PIP process, no.
Mr. Glasgow, could I just ask this one question? Colonel Rotchell, as Mr. Glasgow and I probably discovered that time in the classroom learning the law is no substitute for doing actual cases. Can you help us a bit with the experience aspect of developing skills?
Yes, absolutely, sir. And
speaking for myself, I'm not Mr. Glasgow, of course.
one element of that is obviously the experience that is available internally within service policing, and particularly within the special investigations branch units. But as I think we've already touched on, there's a real importance of ensuring that best practice is gleaned from across other agencies, and the RMP at the time and now maintains an external placement programme with a number of Home Office police forces to allow individuals to go and spend time with Home Office police counterparts to understand the challenges that they face, the ways that they address them, and then to allow us as an organisation to work out how we can best apply that knowledge, that learning, that experience internally to allow the best output for the Royal Military Police.
Is that in part because there is a recognition that the Home Office police forces are exposed to a significantly greater volume of criminal investigation than the SIB is?
Yes, it is. Yeah.
And by spending time with Home Office police forces, particularly with the CID divisions, there's a hope that your service personnel will learn skills that they might not otherwise have had an opportunity to pick up had they remained simply within the bounds of the RMP.
That's correct, and it's a difficult paradox because all of us within defence would like to see offending within defence at the minimum possible level, because that's the best thing for defence and it's the best thing for victims that sit within defence. But that experience is only gained by undertaking investigations into those relevant offences.
If one thinks through the logic of what you've just said, if you don't have the proper people to investigate and uncover the truth, it allows people to get away with crimes and will perhaps encourage others to do the same, since they won't fear the risk of being caught.
It does, which undermines the fundamental principle of discipline and justice within defence.
So if you're not equipped to do your job properly, it allows people to get away with breaking the law.
Absolutely.
In terms of the standards and expectations that you set for RMP personnel and that were set at the time with which we are concerned, we know from Admiral Radikin's evidence of the values and standards that were expected of all UK Armed Forces members, and I'm not going to go through those because he's helped us. But in addition to expecting RMP personnel to adhere to those values and standards, did you set for your servicemen and women further standards of professional behaviour that they were expected to meet?
We did, and in 2012 we introduced the RMP standards of professional behaviour. They were standards that we expected from all RMP personnel all of the time, much in the way you've heard about the Army's values and standards. Would it be useful for me to highlight what those
If you could, please.
standards were? They were honesty and integrity, authority, respect and courtesy, equality and diversity, use of force, orders and instructions, duties and responsibilities, confidentiality, values and standards, discreditable conduct, and challenging and reporting improper conduct. And they were aligned to what later became the College of Policing's Code of Ethics, which was published in 2014, but stemmed from the police conduct regulations of 2012.
And you've mentioned them already, but ultimately, did that collection of standards become known as the MP compass and then the moral compass of the military police?
So it evolved over time, and I think, if I'll just give you the correct date, but we brought the MP compass in as a revision of that initial code of conduct in 2017, and then in 2022 updated it to become the MP moral compass, yes.
And for the avoidance of any doubt, is it simply seen a restructuring of the same values but brought to the attention of the reader in a different way so that it's easier to understand what the expectations are?
I think perhaps so people like me could understand it, yes.
I was thinking more of people like me. The advantage is there's a picture that you can look at which sets out where to find the right ethics.
Setting them out in a simple and straightforward manner so that none of our people are under any illusion about the standards that we expect from them as service police officers.
But the standards haven't changed.
No.
And what you expect of servicemen and women in the RMP is still to adhere to those fundamental tenets that you've just set out.
Yes.
If it's any comfort, very similar standards apply to judges as well.
It is, sir. Thank you.
In terms of the culture of the RMP, there was a study conducted by a senior psychologist at the Centre for Defence Leadership and Management, which was produced in April of 2015. Now, I immediately recognise that I've just picked a date which lies outside the window of the relevant period. But in terms of the information that she gathered, which formed the bedrock of her report, did that largely come from speaking to people who were involved in the relevant period with which we are in fact concerned?
It almost certainly would have done, yes.
It identified that the RMP sees itself as a professional, capable and disciplined organisation comprising mature and motivated personnel.
Yes.
Did it also, though, note that in part the drive to achieve high standards had resulted in a culture of risk aversion?
Yes.
And just to explain that very simply with your help, we've been through the very high standards that you expect of RMP personnel, and we've identified that that lies at its heart with the motto of by example shall we lead. But did that report recognise that when you set incredibly high standards for those people who work for you, there is a risk they might choose not to act so they don't fall foul of those standards and come up short?
That's my understanding.
And in terms of how it is possible for the RMP to readjust its expectations to ensure there isn't a risk aversion into putting a foot in touch, if I can put it that way, is that something that the RMP has tried to grapple with since the report was produced in 2015?
Yes, and I think it's about adopting a learning culture. There are many mistakes that can be utilised as learning opportunities for other people and to ensure that the organisation develops and gets better. And ultimately, the best way to deal with issues, transgressions, challenges is for us to openly investigate them and share that learning within our organisation.
And indeed, is it the recognition of what was in that report that led to the development of the moral compass example of standards, which was done pictorially in a diagram and a chart rather than simply rehearsing it on paper?
This was a key factor in that, yes.
So a recognition that all who are asked to uphold the highest standards of professional behaviour actually understand what is expected of them.
Yes.
Can we turn to deal with a different chapter, please? And can we consider investigations within the service justice system? And in order to do so, it may help if we have one of the charts that you have prepared available for us to consider. I think it is at page 374 within the bundle. Thank you. What you have done is to set out the way in which referrals, investigations and disposals may take place within the service justice system, And it's done in such a way that those who aren't familiar with the process can more easily understand how things work. And we've touched upon this again, as we have with lots of your evidence, early on in the outset when we dealt with the summary. And of course, the starting point, as ever, for many investigations is either the allegation itself being made or, in the service justice system, a referral by the commanding officer. What I'd like to do, please, is to have your help taking us through the chart that you've prepared, which reads quite naturally left to right, although there's a little bit of up and down every now and again. So could you take us through it, please, Colonel?
Certainly, and I think it's worth reiterating at this point those two key and critical start points for investigations within the service justice system, that being an allegation made directly to the service police or a referral from a commanding officer to the service police. That would then initiate the investigative process. And you will see on the diagram there, the first yellow star from the left moving right, entitled Decision to Investigate. And the decision on whether to commence a service police investigation is a matter for the relevant Provost Marshal, be that Provost Marshal, Army, Navy, Air Force, or now serious crime. And that's directly comparable to a Chief Constable's discretion. But I think I need to clarify that by making everyone aware that the RMP are absolutely accountable to the Defence Council for their actions, and therefore it's incumbent on us to record and then maintain those records of all service offences reported to us, irrespective of the seriousness, the complexity, or the apparent solvability in line with the Victims Code. And I think Sir Richard Enriquez highlighted this in his report, the importance of the RMP investigating allegations or circumstances of which they're made aware of, which would indicate to a reasonable person that a service offence has or may have been committed. So whilst I say the decision to investigate, we have a reasonably codified approach to when, where, and then how we would investigate, which is perhaps moving on to the second black box from the left, which is entitled Investigation. From an investigative perspective, we have our own internal policies. We refer to them as military police investigative doctrine, but we also and fundamentally follow national core investigative doctrine through the authorised professional practice as it is now. And I think really relevant to this inquiry was perhaps the capstone piece of national doctrine at the time, which was the Murder Investigation Manual 2006. In terms of our own investigative doctrine, we have that to bring some of the national best practice into a military context. I think context is critical in terms of how, where and why we investigate. Therefore, we do have our own policies or doctrine that sits beneath that.
Is that what's known as the Military Police Investigation Doctrine?
It is, or colloquially as MPIDs.
And insofar as MPID is concerned, just dealing with the decision to investigate first of all, does that document identify within it that whilst there is not a statutory duty on the RMP to investigate, as you've just told us, the RMP should investigate criminal conduct offences and any other offence where there is likely to be a court-martial?
That's correct, yes.
So there is, whilst not a statutory duty, an expectation, because the RMP should investigate.
Yes.
And it reminds the reader that the RMP are accountable for their actions. That's accountable to the Defence Council.
Yes.
And that a record must be maintained of any offences reported so that anyone who wants to is able to look at what the RMP were told and then what they did.
Yes.
And if they did nothing, does that need to be a reasoned decision that is recorded?
it absolutely needs to be recorded as to the reason and the rationale and the decision as to why nothing was done.
So ultimately, the Defence Counsel has a supervisory role over the RMP to satisfy itself that the RMP have behaved appropriately and professionally in regard to all matters brought to the RMP's attention.
Yes.
And in case anyone thinks that that is a supervisory role without any real teeth, is there regular checking at multiple levels of the RMP chain of command of what has gone on?
There is now our own internal policies from the time, set them out in some detail, but to perhaps offer a quick overview of that, there should be initial, what we would have referred to as first tier supervisory management checks on what an investigator was doing, then second tier, which would be at the higher up the chain of command, and then there would be oversight and accountability by the officer commanding, who in an RMP unit would routinely be an OF3 or major rank, then again at the commanding officer, so OF4 level rank, and then externally to the actual policing unit, further assurance checks conducted by headquarters Provost Marshal Army as well.
If we just go back then to your chart, we made our way left to right to investigation, and we can see that after the investigation appears another yellow star to denote a service police decision. And can you explain to us what we need to understand from the yellow star, the EST or evidential sufficiency test, and then the appearance of the term advice, which appears to go backwards and forwards between the RMP and the Service Prosecuting Authority, the SPA?
Certainly, I think it's probably useful for me to first set out the evidential sufficiency test, which is set in statute in subsection 5 alpha of section 116 of the Armed Forces Act, and it states that there's sufficient evidence to charge a person with an offence if, were the evidence suggesting the person committing the offence to be adduced in proceedings for the offence, the person could be properly convicted. That's the test that the service police use to determine whether or not to refer a matter to either the Service Prosecuting Authority or to a commanding officer. And we do so upon exhaustion of all reasonable lines of inquiry. And if there is sufficient evidence, then we must make a referral. For when I talk about referring to the commanding officer, that's for less serious offences. They're set out in Schedule 1 of the Armed Forces Act. And when I talk about a referral to the Service Prosecuting Authority through the Director of Service Prosecutions, that's for serious offences as set out in Schedule 2 of the Armed Forces Act, serious assaults, homicide offences, serious frauds, sexual offences, and many others, but I think that gives the flavour. But also for offences that occur in prescribed circumstances. That decision is made by the investigator, and that decision then allows either the Service Prosecuting Authority or the commanding officer to make a decision on charging. The dotted line that you see that is titled advice between the investigation and the SPA, so between the Service Prosecuting Authority and the Service Police, I think is probably worth me highlighting two areas that are really relevant to that. The first is the statutory obligation that we've already discussed in terms of the requirement of the Service Police where a serious service offence may have been committed but no referral is likely to raise the matter and discuss the matter with the Service Prosecuting Authority.
That's section 116 of the Armed Forces Act.
It is. And the second is what I would call the best practice way of managing an investigation, and particularly a serious or a complex investigation, which is seeking the advice and assistance as early as possible from those that, should it be referred and should it be charged and should it be tried, are those who will have to finally build the case and try it. So the second aspect is about best practice.
In terms of just bringing it to the nature of the allegations which form the substance of this inquiry, we're clearly dealing with the most serious allegations one can imagine. In the event that evidence of an allegation such as that had been brought before a commanding officer, so that there was then evidence that an offence may have been committed, there is a statutory obligation on that commanding officer to refer it to the Royal Military Police. And then, whilst not a statutory obligation on the RMP to investigate, can you conceive of any circumstances in which an allegation of murder or extrajudicial killing would not be investigated by the Royal Military Police?
If there was any form of credibility to it, I absolutely can't see a circumstance where it wouldn't be investigated either by the Royal Military Police or by another agency. And in terms of that statutory duty of a commanding officer, that's correct. It's set out clearly in section 113 of the Armed Forces Act and reinforced in multiple other policy documents.
And insofar as the RMP embark on an investigation of that sort, is that the sort of investigation where engagement with the SPA to get advice at an early stage would be considered appropriate?
Absolutely.
And for the avoidance of any doubt, in the event that the RMP concluded that the evidential sufficiency test was met, that would see individuals referred to the Director of the Service Prosecuting Authority for him or her to consider whether charge was appropriate.
Yes.
But in the event that the RMP concluded that the evidential sufficiency test was not met, the RMP would still be required to provide that decision to the Director of Service Prosecuting Authority for him or her to review it to see whether that decision was in fact the right one.
So I think the exact wording in the Act is a requirement to consult, but yes.
But ultimately it would see you engaging with
Yes.
lawyers at the Service Prosecuting Authority and engaging with the Director to have your decision of no one to be referred to be double-checked and in effect vetted.
Yes, and I think as we touched on earlier, it's been referred to as a safety catch or a safety check.
If we just focus on the serious allegation, and particularly those with which we are concerned, in the event that either the Royal Military Police had referred individuals for charge or the Director of Service Prosecutions had disagreed with the decision not to refer, the charging of any individual would lie with the Service Prosecuting Authority and not with the RMP.
That's correct.
So the decision to charge, as we see here, now the star changes colour. It's no longer yellow for the Service Police. It now becomes blue to denote that it is either the Service Prosecuting Authority or the commanding officer, but in allegations of the sort with which we're concerned, it would clearly only be the Service Prosecuting Authority.
It would, and whilst certainly not an expert on the full codes test, I think if I highlight that the SPA would then, or Service Prosecuting Authority, would then utilise the full code test with its two clear stages, the first being the evidential stage and the second being the public interest stage to make their decision.
And in the event that a decision was taken to charge with a serious offence such as homicide, that would see the individuals charged go before a court-martial where they'd be tried by a board and a judge advocate.
That's correct.
And that ultimately would lead to an outcome, as we see, with the orange star on the right-hand side, which is the judicial decision or the finding of guilt or innocence against them.
That's correct.
Can we just consider, with your help in a little more detail, the role that a commanding officer might play in situations such as this? Because it may be that the inquiry will need to consider whether decisions to refer or not to refer, or to investigate or not to investigate, were the correct ones to have been taken.
Yes, the meaning of a commanding officer is set out in a joint service publication. It's Joint Service Publication 830, which is generally referred to as the Manual of Service Law. And ultimately, a commanding officer sits at the apex of a unit's command and control structure and has disciplinary powers as set out under the Armed Forces Act. For instance, a commanding officer has set out under Section 120 the power to charge an individual with an offence. So it also places commanding officers firmly in the middle of the service justice system, because it confers a range of powers on them, and those responsibilities of a commanding officer for whichever unit they're in command of apply equally at all times, whether they are deployed on operations or not. And COs are ultimately appointed in the main by virtue of the position that they hold, are selected for and assigned into. But there is a provision set out by the Defence Council for certain authorised officers to appoint people as COs. Ultimately, and from an army perspective, everyone has to have a commanding officer. At all times, someone is the commanding officer of everybody. So where conflicts could occur or be seen, there is the ability for the Defence Council nominated authorities to appoint what's referred to internally as a bespoke commanding officer to deal with issues.
So come what may, there's always somebody that you are answerable to.
Always.
In terms of the expectations that are placed upon a commanding officer when an allegation is brought to his or her attention, is that clearly set out so that anyone in that position can understand what he or she is required to do?
Absolutely, and the Manual of Service Law sets that out. It talks about the purpose of an investigation and why investigations are necessary. But in direct answer to your question, it directs COs to investigate incidents appropriately, and it says, and I quote from it, "Where an allegation is made or an incident comes to light, a CO, a commanding officer, at the outset is to consider whether they are under a legal obligation to ensure that the service police are made aware of the matter."
So if we think about what that means in practical terms, when an allegation is made or an incident is brought to the attention of a commanding officer, the very first thing that he or she must do is to consider whether they are under a legal obligation to report that allegation or incident to the service police.
That's correct, and that legal obligation is set out clearly under Section 113 of the Armed Forces Act, and that obligation is for a CO to ensure the service police are made aware of the possibility a serious offence may have been committed.
So once a serious matter is brought to the attention of a commanding officer, he or she is under a legal obligation to report that to the Royal Military Police. where there's ultimately a possibility that allegation might be correct.
Yes, that's
And
correct.
It's as low as that, where there's a possibility.
Yes.
The terms are that whether the offence may have been committed. So that the CO doesn't need to conduct some sort of value judgment or assessment. If there is a possibility that an offence may have been committed, the CO is legally required to report it to the RMP.
It's non-discretionary. It's set out in law. It's reinforced in various regulations, including King's regulations, as well as multiple relative and other policy documents that cover issues that surround it.
And it doesn't matter whether you're a CO of an infantry battalion or you're a CO within the Special Forces. The same legal obligation sits squarely on your shoulders.
The obligation applies to anyone who's a commanding officer.
And in the event that the commanding officer was in any way confused about the legal requirement in section 113, the Manual of Service Law reiterates that very simple legal duty, doesn't it?
It does.
It reminds commanding officers that they have a legal duty to ensure that the service police, as soon as is reasonably practicable, are aware of an offence or a suspected offence. And if we just step outside the confines of the law for a moment and think about the allegations which form the substance of this inquiry, and they are allegations of extrajudicial killing or murder, those are precisely the sort of allegations that a CO is legally obliged to report to the Royal Military Police.
It's a Schedule 2 offence under the Act, so it absolutely is, yes.
It isn't a case that the CO might want to embark on his or her own investigation because the referral must be made as soon as is reasonably practicable.
That's correct.
And again, you've made it abundantly clear in what you've just told us, but in case anyone is in any doubt, there is no discretion at all vested in any commanding officer as to how he or she complies with that legal duty.
No.
And perhaps it's blindingly obvious, but when we're dealing with matters as serious as the ones we are here, the idea that anyone has any discretion would simply be abhorrent, wouldn't it?
I agree.
You've identified that a failure of a commanding officer to meet their statutory duty pursuant to section 113 is itself an offence, and you'd be considering in that regard failure to attend or to perform a duty or conduct prejudicial to good order or discipline. It's also a criminal conduct offence in its own right, isn't it?
It could be, yes.
But if one steps outside the confines simply of military law, and I mean no discourtesy in so doing, it is also quite clearly potentially misconduct in a public office or perverting the course of justice.
Absolutely could be, yes.
Have you done a check of the relevant records to see whether any commanding officer in the period with which we are concerned has either had action taken against him or her or has been referred for a consideration of action being taken against him or her in respect of failing to report any matter to the RMP?
I have conducted that check and it returned no results.
And just so I understand what it is you mean by no results, do you mean none in respect of allegations that concern murder or extrajudicial killing, or do you mean none in respect of any serious allegation of any sort?
In terms of the check that I personally did, it related to offences related to operations and within the relevant period. So in Afghanistan, between 2010 and 2013, there were no records.
So all and any offences?
In terms of specifically relating to the failure of a commanding officer to perform his duty or her duty.
But of course, if we go back to that rather trite observation I made inelegantly earlier on, that you can only investigate what you're aware of, the mere fact that a commanding officer has not been reported or proceedings have not been instituted in respect of him or her doesn't answer whether there has been a failure to report by any commanding officer.
No, it doesn't.
It simply means that the RMP or anyone else was not made aware that someone considered a commanding officer to have fallen woefully short of their legal requirement.
That's correct.
Insofar as one has to consider the obligation upon a commanding officer in this regard, is there a danger that a commanding officer who has lived and worked and fought with those under their command might be reluctant to refer serious offences to the Royal Military Police?
I think that's a difficult question for me to answer. I would come back to the values and the standards of the army and the values that are incumbent upon everybody that serves to have the moral courage, the discipline, the integrity, and the selfless commitment to ensure that no matter how difficult a decision might be to do so, that they did it.
It is correct, though, isn't it, that one of the conclusions and observations of the report provided in 2015 by Her Majesty's Inspectorate of Constabulary's Fire and Rescue Services was that they had had reports of individuals who said that commanding officers had abused the power that they had and had taken advantage of their position and chosen not to refer matters, but to have dealt with them at commanding officer level rather than refer.
They did, yes.
So the expectation that people will uphold the standards, whilst laudable, it is known, isn't it, within the military that those standards are not always upheld, even by commanding officers.
I think there has to be some context as well to that extract, because my understanding is one of the issues was not necessarily commanding officers not doing anything, but applying, in some cases, the wrong policies. For instance, we heard, I think, from Brigadier Ebel yesterday about administrative processes within defence, akin to employment law, which can lead up to the termination of someone's service. And my understanding is that some of those instances were people applying the wrong investigative process to a matter rather than simply turning a blind eye to an issue.
You're quite right. The abuse that was being spoken of was whether a commanding officer had chosen to deal with a matter at commanding officer level rather than reporting it to the Royal Military Police. Yes. That's the abuse that was being spoken of, but nonetheless, an abuse of the position and trust vested in the commanding officer to do the right thing as regards that particular allegation.
Yes.
And here the inquiry will need to consider whether observations such as a desire to nip allegations in the bud is a proper exercise of duty by a commanding officer, or whether in fact it is a criminal offence.
Yes.
And just to follow up on that, since it's an offence for a commanding officer under Section 113 not to refer a serious matter to the RMP as soon as practical, if another commanding officer comes to learn of a colleague commanding officer who hasn't referred, then that second commanding officer is also potentially guilty of an offence? Or is that technically
Well,
not correct?
I think, if I may, sir, if I could just refer to the exact wording of the Act, because the exact wording of the Act is that if an officer becomes aware of an allegation or circumstances, he must, as soon as is reasonably practicable, ensure that a service police force is aware. We reinforce the role of a commanding officer for those who are under their command. But as I also said, everyone has a commanding officer. So a commanding officer has a commanding officer. So in an instance where a different commanding officer were unhappy with something or wished to report something, in the first instance they could report that matter to the service police. Ultimately, they could then report that matter to their commanding officer for their commanding officer to deal with it. So the fact that everyone has a commanding officer means that there should be a catch-all to prevent that.
Indeed, my point is that if the commanding officer of the commanding officer got to learn of the fact that his subordinate had failed to report something as soon as reasonably practicable, that would impose a duty on the commanding officer of the commanding officer to report that offence, wouldn't it?
It would, sir, yes.
Can we turn to deal with a slightly different chapter, please, now? And you were asked to give assistance to the inquiry in respect of the serious and complex investigations that have been undertaken in the decade prior to Operation Northmore, so the period January 2004 to March of 2014. We've touched on some of the numbers already when we've looked at the relevant period within Afghanistan, but you provided a helpful chart to set out the offences that there had been investigated and to give their numbers over that just over 10-year period. Can I ask, please, that we look within the exhibit bundle to page 1303? And I hope you'll be familiar with the serious investigation table that you have prepared. Your exhibit's KR37. And we can see that over the period of January 2004 to March 2014, you've provided the number of murders, attempted murders, manslaughters, sudden death and death during armed conflict, war crimes, rape, and then what are termed special investigations, which is a category used for unclassified or unspecified allegations that are nonetheless serious.
Yes.
You've given us a total, and then that's been broken down into offences that occurred in Afghanistan and then elsewhere in Iraq or in other locations. And if we look initially, please, to the total figure, we can see provided here that in that 10-year window, some 288 offences of murder were investigated by the Royal Military Police, of which 138 came from Afghanistan, 82 from Iraq, and 68 from other locations. But again, do we need to apply the same caveat to this table as have been done previously, that the vast majority of those murder investigations concerned the murders of British service personnel on operations? So the purpose of the investigation was to assist, as was then Her Majesty's coroners, now His Majesty's coroners, to determine the where, when, how.
We absolutely must apply the same filter, and I think it's also very relevant to just highlight the way that our information system holds data. So if an incident or an offence is recorded, it will, in accordance with the counting rules, go on the system as that offence. Sometimes that might be because we have reported an offence or recorded an offence in our system because we've been asked to provide help to another policing agency. So, for instance, 68 murders in other locations, many of them would be offences that were being investigated either by a Home Office police force or another policing agency for which we'd provided assistance, but were not necessarily the primary investigative authority in.
There's almost a double caveat here, that not only do the significant majority of these investigations concern assistance given to coroners, but some that fall outside of that might involve assistance to other Home Office police forces rather than the RMP being the lead investigating force.
Yes.
I'm not going to give the same breakdown to other offences other than to identify that within Afghanistan, in that 10-year window, 9 offences of attempted murder were investigated, 6 of manslaughter, 254 of sudden death and death during armed conflict, 2 of war crimes, 3 allegations of rape, and then 76 unidentified serious allegations that resulted in special investigations. So again, we can see that the RMP had its work cut out in order to deal with all of those investigations whilst on deployment in Afghanistan, and at the same time dealing with investigations elsewhere.
Yes, and that's only an example of specified offences. That doesn't include the full totality of perhaps less serious investigations.
And would it be fair to say that we're looking at the top of the pyramid here, and the number of offences grows exponentially as those offences become less serious?
Yes, it does, yeah.
So whilst the SIB were busy with these, they were busy with other allegations, and the GPD units were perhaps even busier at times.
In terms of volume, yes.
But the volume itself is significantly less than Home Office police forces would have to deal with, whether it's uniformed or CID personnel.
I mean, I don't have personal first-hand knowledge, but I believe so.
In terms of the locations that we've got here of Afghanistan, Iraq, and other locations, at the relevant time, was the RMP committed almost constantly to global deployment?
It absolutely was, and at the time, sir, we had a permanent presence in garrisons across both the UK and Northern Ireland, in Cyprus, in Canada, in Kenya, and Belgium, the Falklands Islands, Brunei, and Diego Garcia, all of which, at the relevant time, had a permanent RMP presence.
And clearly you had troops who were deployed in Operation Herrick in Afghanistan, but also in Iraq on Optelek.
Until 2011, yes.
And were you also involved in assisting the UN Operation Tosca in Cyprus?
Yes, the RMP has a permanent presence in supporting that.
And presumably up until the drawdown from Germany in 2013, there was also a garrison based there in Germany, and the RMP had a permanent presence in Germany till all service personnel were withdrawn.
They did, and Germany, or British Forces Germany, was perhaps our most intensive tasking. It required 2 of the RMP GPD regiments to be based in Germany, and 1 of the 2 SIB regiments prior to the formation of a single regiment in 2013 to be permanently based to police and investigate not only British service personnel in Germany, but a whole host of other individuals, including the dependents, so families of British service personnel, and civil servants and other specified categories of civilian personnel supporting British forces in Germany.
At times, did it feel as if the RMP was spread thin?
think any organisation would like more resource, and people feel the pressure of that. And I think the RMP felt spread thin, particularly when you layer on top of those permanent garrison presences around the world that I've described, where our primary function was to provide policing and investigative capability with 2 concurrent significant operational deployments to Iraq and Afghanistan. And then on top of that, and a very RMP specific issue, was the requirement to provide a significant number of close protection trained personnel to fill close protection teams for both the military and other organisations around a multitude of countries around the globe.
If we just focus for a moment, if we can please, on Afghanistan, insofar as the numbers that were deployed on the various rotations, in terms of early deployments in around about 2011, as far as the General Policing Duty Unit was concerned, did that see somewhere around 100 or more personnel deployed in order to assist the Theatre Provo Company?
It did, and I think I've used the example of Op Herrick 17 because we have some very clear breakdowns and records from that, and the number of GPD personnel to meet the multiple commitments was just over 100, yes.
Now, Op Herrick 17, which you picked as your example, is the time window November 12 to April 13.
Yeah, October, yes. October 2012 to April 13. So
Sorry,
yes.
October 12 till April 13. So that saw, as you've just told us, just over 100 GPD officers, GPD service personnel deployed. I think it was 107, in fact, in total.
I think the 107 included the SIB investigators, but that's again offset by the large number of close protection operatives required.
I mean, in terms of the close protection support, how many were they?
Well, at that time, as a snapshot, there were 20 individuals required every 6 months to do that. But I think it's right to point out that not all 20 of those would have come from within the GPD company that was deploying. A minimum of 2 would have done. The others are likely to have been drawn from across other RMP units where other people held that qualification.
Because if we think in terms of just over 100 GPD servicemen and women, there were 11 SIB investigators and then 4 attached GPD personnel to the SIB team. So giving you an SIB team for 62 section of 15.
Yes.
And that's at a time when there were between 9 and 9,500 members of the UK Armed Forces deployed in Afghanistan.
That's correct.
So not good numbers for man marking.
Challenge.
Insofar as pre-deployment training was provided, and I don't want to get into too much of the detail because we've touched on Soldier First already, and we know from Admiral Radakin's evidence that understandably pre-deployment training was extremely important. But did you have expectations of the standards that the RMP personnel would meet in order for them to be deployable on any rotation in Afghanistan?
We did, and they were at that time, towards the end of 2012, they were known as the Cat 2 plus standards, sometimes referred to as the theatre entry standards, and they were the minimum requirements for personnel to meet to enable them to deploy and to operate in Afghanistan.
And those minimum standards, were they principally aimed at fulfilling the soldier first side of the RMP job?
They were, yes.
insofar as there was any bespoke training that was given, did those who were deployed undergo bespoke, what's known as special to arm training?
They did, and that included specific investigations training, and specifically focused on how support to the coronial process could be provided. It also focused on other areas or other really key areas of the MP capability, particularly providing detention advice and handling, training on mentoring host nation forces, also on biometric and forensic support, and other areas as well, but I think they're the key ones.
Could I just ask you about the 4 members of the GPD unit who were to be selected and then attached to the SIB, that on Op Herrick 17 saw the number of 11 swelled to 15. Those you told us before were specially trained as crime scene investigators. In terms of identifying who would be best placed to become one of those 4, was there a review that was conducted of GPD personnel performance to help pick them? Did they have to pass a test, or was there anything special about it?
I'm unaware of there being any specific selection process other than the requirement for 62 section to have more crime scene investigators who trained through the Defence School of Policing and Guarding.
And that was a bespoke package given to them to enable that they were able to provide effective assistance to the SIB investigators.
Yeah, so at the time, the Defence School of Policing and Guarding ran qualification courses for all crime scene investigators within the service police, and those 4 individuals would have attended that course.
In addition to those pre-deployment bespoke packages that we've spoken about, did the SIB have to undergo the same theatre entry standards and their own bespoke training package?
They did. So the Cat 2 Plus, or the theatre entry standards, remained. In addition to much of the special to arm training that the GPD elements would have done, the SIB personnel conducted their own special to arm training, which was more focused on the role that they were likely to conduct within Afghanistan. That included areas such as disaster victim identification training. This is where those experiences from previous rotations came in. Forensic awareness specifically focused on Afghanistan. They also, I'm led to believe by the contemporary records, had training on how to interact with shooting incident reviews. And they also had external presentations from a number of different areas of the Ministry of Defence, including the Defence Inquest Unit, from the Serious Equipment Failure Team, who look at equipment failures, from elements of UK Special Forces, and also from what are now the Defence Safety Authority, but previously were the constituent parts of the Defence Safety Authority.
If we just look very briefly, with your help, at the general policing duty elements who were collectively to become part of what you told us was the Theatre Provo Company, or the Theatre Provo Group, were they then commanded by someone outside of the RMP, or did they still sit under the RMP chain of command?
No, they were always commanded by an RMP major, known as the officer commanding.
And the various roles that they were expected to perform, I think you're able to provide in your statement a breakdown of the different GPD personnel that would form part of the Theatre Provo Company or Group. It's your paragraph 135, if that helps. Could you just take us through the various roles that they were performing, so we have an understanding of what was expected of the RMP in that particular area.
Yeah, of course, and the breakdown that I've utilised relates to OPERIC 16, which would have been in 2012, April to October 2012. But it's broadly indicative of other rotations as well. So there would have been a headquarters element, so the Theatre Provost Company or Theatre Provost Group headquarters, which would have included a number of personnel. In this instance, it included 5 personnel, including the company commander, who is an OF3, so a major, an operations officer, who would have been an OF2, a captain, and also the company sergeant major, who would have been the senior soldier within the deployed RMP formation. In addition to that, it would have had, or it did have, what's called a brigade provost staff. I think we may talk about the brigade provost officer shortly, but on this rotation, not to assist the brigade provost officer, there were also a number of other staff. I think then the 2 key groupings within the Theatre Provost Company at the time were those that were entitled general support elements and close support elements. Those general support elements were those that conducted what would be more akin to routine military policing tasks, predominantly focused around the main operating base areas. They're the very few, and on that rotation it was 10 GPD personnel who would have been responsible for conducting the majority of those lower level investigations across Afghanistan. To then just highlight the close support personnel, and in contrast to the 10 personnel providing general support, on that rotation there were 70 personnel providing close support to both battle groups and what was also known as the police mentoring and advisory groups. I think beyond that, I've touched on close protection, but there were 2 personnel providing close protection to the commander of Task Force Helmand. There were the 4 junior NCOs attached to the SIB section, to 62 section. There was an officer providing detention oversight, and then, of course, separately but linked was 62 section SIB.
And just to pick up on something that you'd said a moment ago, in terms of those individuals who were part of the general support team, they were 10 in number, and it was to those 10 individuals that fell the task of investigating all of the lower level criminal or disciplinary offences that might be brought to the attention of the RMP.
The vast majority, yes.
In case it assists to identify the function of the RMP support throughout the deployments, if we just look to your paragraph 140, and it may be that this will enable us to conclude this particular area when dealing with the GPD, and we can return to consider section 62, I'll try that one again, 62 section SIB after lunch when I've got my words back. Insofar as the function of the GPD personnel, have you identified in your statement that it was to provide operational support through the delivery of tactical level evidential recovery, advising on delivering surety to detainee handling during and beyond the point of arrest, and supporting ANP mentoring?
Yes, I have.
And you'd also identified that when required to conduct investigations into those they were supporting as the closest personnel to an incident, and due to the complexities of movement, they would do so by conducting immediate investigative actions such as securing scenes, gathering evidence, and taking initial accounts before subsequent reinforcement from others or from the SIB would be brought in place.
Yes.
So if we just think about that for a moment, in terms of investigating those you are living and working and fighting alongside, a recognition in your statement that they might be required to conduct investigations, but those would be the initial start of any investigation, at least insofar as it's a serious matter, and that would then be passed on either to others who were not directly involved with those who were the subject of the investigations, or passed on to 62 section SIB. And was the purpose of that, where possible, to try to avoid the conflict that I've already asked you about that might see people investigating their friends and comrades?
I think there's an element of that, but I think actually the bigger part of it was the criticality of the close support role in other areas, and a clear understanding of the importance of investigating crime and providing the best service to victims meant that actually those people in very remote forward locations were not the best placed personnel to conduct those investigations anyway, and the best service to the investigation could be provided by those slightly further back with the time, the space, and the ability and perhaps more resource to be able to deal with them in the most appropriate manner.
So an investigation, or at least the commencement of it, wouldn't be delayed so those persons best placed could arrive.
Correct.
The investigation would begin in a timely fashion.
Yes.
But those best placed to take it forwards would arrive as and when they could and then take over.
Yes.
And hopefully at the same time that might avoid a conflict if there was one.
Yes.
So I see the time. Would that be a convenient moment for the break?
It would indeed, Mr. Glasgow. Thank you. Colonel Rotchell, remind all witnesses not, as you well know, to discuss their evidence with anybody during breaks. We'll break now, please, until 2 o'clock. Thank you very much.